The Electoral Act. We thought we were done with it, but then not quite, because since then, the executive, that's what the executive has sort of reacted following the National Assembly declining to go ahead with Mr. President's suggestion of deletion of a particular section that he felt was offensive. So what we're going to do now is that let's just give you, another film report. As we also will be speaking with Honorable Benjamin Kalu, who will be joining us on Zoom. He's the spokesperson for the House of Representatives. The Senate also met on this yesterday. But in the meantime, here is an overview. We'll come back to studio after that.
A federal high court in Umuahia, Abia State, ordered the Attorney General of the Federation to immediately delete Section 84, subsection 12 of the amended Electoral Act. The section reads, "No political appointee at any level shall be voting as a delegate or be voted for at the convention or congress of any political party for the purpose of the nomination of candidates for any election." Members of the House are enraged by the controversial judgment as Katsina State Legislator Sada Soli brings it up under matters of privilege. He says the judgment breached his right as a lawmaker.
A court, a judge, somewhere, Mr. Speaker, is given that right to an executive appointee encroaching into the principles of separation of powers.
Others who spoke on the motion cautioned against dragging the National Assembly in the mud by usurping its functions.
In the Constitution, where there is separation of powers, and where we have been made by the provision of the Constitution for us to make laws, that somebody is trying to do our job,
the court should have made an order for the National Assembly to be joined before taking any action.
Members of this institution must rise against this aberration. We are not only lawmakers, we must be custodians of laws, and laws must have to be obeyed in this country.
I cannot sit here and allow the institution which I, at this present time, head and lead, to be ridiculed under my watch.
Arising from debate on the matter, the House resolved to appeal the controversial judgment. It also called on Abubakar Malami to stay action on the execution of the judgment, while it agreed to petition the National Judicial Council on the matter. President Muhammadu Buhari signed the Electoral Act Amendment Bill into law in February on the condition that the National Assembly will expunge Section 84, subsection 12. But barely 1 week after, a federal high court sitting in Abuja barred the President, the Attorney General of the Federation, and the National Assembly from tampering with the law. Joke Adisa, TVC News, Abuja.
Joke Adisa there. So that's the scenario. The first communication with the public from the National Assembly was that it was amassing a legal team to advise it on how to proceed, because it would have been a shock. I don't know if it was a rude one, but it certainly would have been a shock having signed it, and then within days you're looking for an amendment. It's not every day that you have that kind of scenario. Now, we just heard Honorable Gbajabiamila, their speaker, saying that, they were not going to just sit down and take it. It looks like they're gearing up for whatever it will take by way of a fight, right?
Mr. Yori.
Yori, please. Oh, I beg your pardon.
Okay.
Well, sorry. I hear that someone is on the phone and has been on it for quite a while. Mazi Okoroafo. Good morning to you, sir, Mazi.
Good morning, sir. Good morning, our guest.
Indeed. Thank you.
Yeah, you see, the issue of appeal court and the National Assembly going for the appeal and the rest, there is something I've just discovered. Are we saying that the National Assembly, when they come out with an act or just anything, that we continue going to court to amend? It doesn't make sense. What's this? Now look at the offices. Thank God they have settled the issue of chairmanship. Now, do you know that it is not only the chairmanship that matters? There are other key offices, the secretary and the PRO. It's especially the secretary. It matters a lot in any organization. But we only concentrated purely on the chairmanship of the. We have to look at who will be the secretary. How powerful is that secretary? Even the PRO. As you are seated there, I will try to call the PRO of the House of Reps. Now, do you know that anything he says or speaks covers the right of National Assembly member? That is the job of a PRO. That is why the APC, the post of PRO and the post of secretary, they have to be very careful. Because the way this issue of consensus candidate, they have now factions. We don't know those people are against whether they will stay in the party or they will pull out to join another party. That is the question that we toss.
All right.
But the issue is this: running to the court, second per second, this issue of Act Parliament is not good.
Okay.
Because it's 2023. If we continue going to court, and the decision is not helping matters. See the judgment in Akwa Ibom, see the judgment in Cross River, see the judgment in Enugu, see the one in Abuja. You see, we are distorting everything, make this time look as if we are not ready. Thank you very much.
Thank you very much, Mazi. And again, apologies for keeping you waiting. Mazi actually waited for that call right from when we went on break and stayed through. Well, actually, we can now speak with the spokesperson for the House of Representatives, Honorable Benjamin Kalu, who is joining us via Zoom. Good morning to you, Honorable Kalu. Okay, I lip read you saying good morning, but we didn't get the sound here. So I just hope that we can sort that.
Good morning.
Thank you very much. Good morning, Honorable. Now, as we were saying, the first thing we heard was when the news, shall I just say, when the news came through that the executive was actually working towards, and indeed has achieved, an amendment, achieve a limitation. And the first thing we heard from the National Assembly was that you were putting together a powerful legal team to advise you on how to go. Now, we just heard, and you know yourself because you were there, Honorable Gbajabiamila saying that not on his watch would this kind of, I think he must think of it as a slight, happen. Tell us a bit more about this and how far it could go in terms of the National Assembly standing its ground on this matter.
Yeah, thank you very much once again for having me. And as you know, the legislature is the fulcrum of our democracy. And beyond Femi Gbajabiamila, the Speaker of the House of Representatives, it is an institution that will outlive every one of us who are role players currently in the space, legislative space. And based on that, we must take steps to protect the institution, to avoid the kind of harassment that we are feeling at the moment. We feel harassed in the sense that we did not act beyond the scope of our mandate. The parameters of our mandate empowered us to make laws that had not been taken care of by our grown norm. And the sections mentioned in their kindred form, the 6 sub 6, 66, sub 1, paragraph F, the 107, sub 1, the 187, the 182, the 137, all of them put together. They speak to public servant, which has no relevance to the issues we wanted to address with 8412. 8412 was differentiated if you look at 318, which clearly stated who a public servant is. And we are mindful of not offending the provisions of our Constitution when we are choosing the words during drafting. We said political appointees, which may not have been, contemplated. by the drafters of the Constitution when they did that. So to come and be told by a court without any kind of notification that a piece of legislation made by the Parliament should be deleted and gazetted, a consequential order that we consider very overreaching in nature, is offensive to the essence of the existence of the legislature. And that is why you saw the reaction from the members of the parliament. We are united, both minority and majority in the House. We are united on this. And we are saying no, something needs to be done, because why were we not necessary parties? You know, why were we not, since we made the law, why were we not invited?
Exactly.
Even if the plaintiff insisted that, okay, we're supposed to choose who becomes a defendant in this matter, but the judge suo motu supposed to have known that, in line with fulfilling the dictates of natural justice as it concerns fair hearing, that these members of the legislature played a role on this. We should invite them to come and explain to us the legislative intention which they had, the purposive interpretation of 84-12 when they made it. We were ignored. It was even taken away from the jurisdiction where we're supposed to be accessible, more accessible. It went from Abuja to Umuahia, and you'll be shocked to hear that just a day before that judgment, the similar judgment was given, but in a different and more, intelligent and manner in Ibadan by one Justice Agomo, who handled the same issue with the same subject matter, and what he did was to throw the matter away on the grounds that it even lacked locus, because locus is part of determining jurisdiction when it comes to matters like this. And the judge was well detailed in explaining why the gentleman who came to court had no nexus between him and the issue of the subject matter of the issue, and that it should not be open to general public. It's not a public right. It's a personalized right, because if you define 84-12, it referred to a certain group of persons whose right must have been infringed by that particular piece of legislation, or there's a direct impact of injury to them. Every gentleman running to court and asking for decision on the piece of legislation made by the parliament is going to cause chaos if we allow it to stay. Okay. It will be a wrong precedent. That is why we are rising up and we're saying no. Certain issues should be looked at and it should be differentiated. 84 sub 1-2 should be differentiated from the catalog of all these sections that I just mentioned now. Mm-hmm. Before now, the letter of Mr. President to the House of Representatives, if you may recall, was that it offended Section 40, which had to do with the freedom of association. And another one was that it offended Section 42, which had to do with it not being discriminatory in nature. Even if you extend it to Section 38, which had to do, with conscience, religion, and other, all these are irrelevant sections with regards to the interpretation.
Okay, Honorable Kalu, I beg your pardon. I got to interrupt you because a call. I've been holding up a call. Mr. Joshua in Irewolede, I want to thank you very much for holding on all that while. Please go ahead now.
Yeah, I understand. Good morning, sir. Good morning to Honorable Kalu and your guest.
Yes.
I just want to offer my words of encouragement to the Honorable. The House, they've spoken well. They are standing for democracy and standing for Nigeria. This is, I think, placing Nigeria above personal interest. If they can go the whole hog, they would have sent a statement to Nigerians that they are ready to stand on the side of the people. I don't want to go to the legal nitty-gritty of that particular law, But the Honorable made a statement on Kuyori that they were feeling harassed. That was what I saw in the body language of Malami. It was like harassing somebody. This is what I'm doing. This is what I'm going to do. This is how I'm going to do it. And I think we've gone beyond that. The people who are making laws, who are in charge of this business of ensuring that laws are complied with, should show to the public that they too are above board. They should demonstrate that they have the power to make the laws and to obey the laws themselves, and not, create a kangaroo situation for us in the country. And for the president, Okuyori, I commend him. He should stand for APC, as it were. I'm not a politician, but he should stand for that party, because the opposing parties will sponsor candidates to disrupt APC, so that we can have a political party that will give us democracy in Nigeria. Okay. I appreciate you, sir.
All right, then. Thank you very much for calling in. And once again, thank you for understanding. I didn't want to interrupt the Honorable as he was explaining that important aspect of it. Now, among the things that he said, he said he's looking for, well, it might be ideal, but it is what we all want. Not that personal interest is not what really serves as a motivation for people when they take these acts that affect all of us. Could you relate to that? This whole question about people acting in personal interest more than that of the country.
Okay, you said I should not call you Mr. Yori.
Yori, please call me Yori.
Okay. Thanks for delegating that freedom to me. You see, I'm troubled as a result of the constant changing of the sections of the Electoral Acts. You see, by now we should be talking of building institution, not building men for their personal interest, not building men or personality because of their selfish reason. But you see, all these alterations were ordered. Most of the alterations in the Electoral Act were ordered by the courts, up to the level of the Supreme Court. Okay? Now, I don't see anything so bad about it that a high court, the Federal High Court, is looking at the sections that may contravene the Constitution. Okay? But the only aspect is that you cannot just sit somewhere and ordered without listening from the other party.
What the lawyers call ex parte,
ex parte or whatever. I don't agree with it. Now, you see, I would like the spokesperson, Benjamin Kalu, to tell Nigerians that there was no agreement between the National Assembly principal officer and the president that the president should send a letter for amendment of that section 84. 12. He should tell Nigeria there was no agreement before the president signed it. I'm a journalist. Mm-hmm. I'm also a Nigerian. I'm not speaking for the president. But I know that, look, and I felt it and I could feel it, that there was an agreement between the presidency and the National Assembly that, okay, you can sign it, then at the end of the day, bring a letter in respect of the amendment and we will look into it. You see, in Nigeria, we should not play politics.
In fact, so much so, I think I heard that in the response of the legislators that were there. It might have been one of the principal officers that, thank you, Mr. President, for expediting action on this. Please forward, whatever your concerns are so we could look at that. Honorable Carlo, coming to you on that particular point, how would you comment?
It will be big slide on the legislature for anybody to hold the opinion that we entered into an agreement with Mr. President before he assented to the bill. It's not our personal property. the bill we are talking about is in line with our legislative agenda to bring electoral reform, which every one of us, those who are participating and those who are still sitting on the fence, needs for us to advance our democracy to where it ought to be. The space needed to be cleared, and it is through legislative intervention that you achieve that. Did we coerce Mr. President, by implication of what the gentleman just said, into signing a document that we all have been yearning for, a document that represents the wishes and the desires of Nigerians just because of a particular clause? And what exactly is in that clause that is so important to the present legislature that they need to use it as a tool for the executive to sign and then let us send the letter? Let me tell you what happened. When Mr. President was advised against that particular section, Mr. President, after signing, had a meeting with the leadership of the National Assembly, who tried to inform Mr. President. This is post-signing, not pre-signing. There was no lobbying tool that was used on Mr. President to make him sign, and then later on for us to review. No, it was when Mr. President raised it after signing and said, granted that I'm doing this, I need you to revisit this. The leadership of the National Assembly had an audience immediately after that signing with Mr. President. The document has already become, been passed into a law by his signature before they went into the meeting. And the meeting was that, Mr. President, probably you misunderstood 8412. This remains the intention of 8412. I'm privy to that discussion because I was briefed by the leadership of the National Assembly after the meeting with Mr. President. I asked them, what did you now tell Mr. President? They said, Mr. President, look at the explanation with regards to 8412. Mr. President said, oh, really? Is that how it is? Okay, engage with the AG and the Ministry of Justice and make sure this thing is dusted. This explanation will clear the space. Before we knew it, the letter came. While we were still looking at the letter, litigation started. 2 litigations of the same matter, the same language, the same prayer, in 2 different courts. One in Southwest, one in Southeast. The judge on the 17th of March ruled against it for lack of locus and all the rest of them. One in the Southeast, a day immediately after that, went for it. And if you look at the provision of that particular piece of legislation, it has nothing to do with public servant. So what are we fighting about? Are we saying that if we find a gap that is in our space that was not taken care of by the Constitution? Because it's another thing if we are not respecting the supremacy of the Constitution in the course of our drafting. We are careful enough to know that what the Constitution has provided for, we are not to legislate on it again or contrary to it. But there was a gap that did not take care of political appointees. And we said, no, we need to take care of it with 8412. We knew what we are doing. And we will take exception to anyone who feels that we are just a gathering of unintelligent legislators who just come in here, not knowing our right from our left, not understanding the law and making law. We are talking about a speaker that has been in the House for almost 20 years. Who has made laws over and over again, and a lot of us who are lawyers who have been in practice for a while, coming in to tell us that what we did was an exercise in futility.
Honorable Kalu,
that we were not on the public of our own when we made that legislation.
Excuse my interrupting you, Honorable Kalu. So yes, we've almost run out of time. So how far is the National Assembly from your view? Ready to go on this matter? By that I really mean, what does the law allow? For instance, it doesn't mean that you go to the full extent of the law. For instance, if you send a bill to the president, it is known that if he doesn't sign it after a certain period of time elapses, and all of that. So how far in this case do you think the National Assembly is going to go, or does that still remain to be seen?
No, let me refer to what you just said about you sent the bill to the president. This bill is now an act.
No, I know. I understand that perfectly.
It is alive.
I understand that perfectly. Okay.
Yeah. So now on the issue raised on a particular provision, a particular section of the bill, which we know has not been raised, in the manner it ought to have been raised, we will challenge it, like we said. We raised 2 resolutions and say in the House, unanimously, we said we are going to file to be a necessary party, and then we'll exercise the right of appeal on that, because you cannot foreclose our right of appeal as necessary parties by the execution or order, which we felt was the consequential order was too overreaching. And that was why the second arm of our resolution was that Attorney General, you have to stay execution. You have to wait for the printing. The reason being that even if he goes ahead to print it, even if he goes ahead to gazette, remember, gazetting is our function as legislature.
Okay.
The printing is theirs, but we are the ones who gazette. So if he goes against it and try to comply with the laws of the Federal High Court, we still have, based on Federal High Court rules, we still have the 90 days that is counting for us to exercise our appellate right.
All right, Honorable Benjamin Kalu, I'm so sorry. Thank you very much, sir. I really apologize. We've run out of time completely, but I do want to thank you immensely for making time for us this morning, and quite frankly, clarifying the perception of how it is working within the House of Representatives. Thank you very much, Honorable Benjamin Kalu, spokesperson for the House of Representatives.
Thank you. Thank you for having me.
All right, then, our pleasure. So we've completely run out of time now, but you got a single liner in terms of where we find ourselves with this. Will it be the presidency or the law?
Yeah, it's from the perspective of the two. Okay, I just want to appeal that the National Assembly and the presidency should be reasonable enough to cooperate and work in tandem for the goodness of Nigeria.
Thank you very much. We're going to have to leave it at that. Bola Olajuwon, Assistant Editor of The Nation Newspaper. Thank you.